Good evening. Thank you, Beth, and welcome everyone. Just a brief introduction about our foundation. We support the work and mission of Columbia Memorial Health, which is to provide exceptional healthcare services to our rural communities. This is made possible through the generosity of our donors. Our hospital is located in Hudson with over 40 physician practices in Columbia, Greene, and Dutchess counties that include primary and specialty care, pediatrics, and rapid care centers. To learn more about our work and future events, we hope you will join us. Please visit our website at givecmh.org. So thank you again for joining us this evening, and I will now turn the program over to Jim.
Good evening and welcome. My name is Jim Armstrong, Vice Chair of the CMH Foundation, and I'm very excited to be back introducing our featured speaker, Lou Pierro. But before I introduce Lou, I wanted to take a moment to give a perspective of some real life implications when estate planning is not done and how it can affect the emotional and financial health of those left behind. Estate plan is one of the most important gifts that you can give your loved ones at the exact moment when they need it most, when they're grieving the loss of you. If you've ever been directly involved in the affairs of someone who has passed, you know that there are many things that you have to consider. There's writing an obituary, meeting with funeral directors, setting calling hours, designing memorial posters, arranging friends and family receptions. The list goes on and on. And that does not even touch on palliative care issues prior to a death. Now try adding the job of executor to your mother or father's estate when there's no estate plan to speak of. You may find several retirement accounts with old and unrevised beneficiary designations. One current wife with children, one former wife with children, numerous brokerage accounts spread out over several investment firms, old pension plans, long since forgotten, a pile of stock certificates sitting in a safe deposit box, half of which have gone through some type of reorganization, a valuable coin collection that 2 grandchildren recall granddad promised them. You can see how this could get out of hand and how a person often not accustomed to estate proceedings might become overwhelmed, frustrated, and even angry. And although hiring a professional like me at a late stage can be helpful, it also can be costly. I see this all too often. While certainly it is true that having a thoughtful and well-designed estate plan is prudent and a good business decision, as you'll learn later, what is often overlooked, in my opinion, is how it can lessen the pain and stress of loved ones left behind. That's what I think about when I think of a good estate plan. So thanks for listening. Now on to Lou. Lou Pierro is the founder and principal of Pierro, Connor & Strauss, a firm that concentrates in the areas of estate planning, estate and trust administration, elder law, and special needs planning. He has been elected to the list of best lawyers in the Hudson Valley, has served on and chaired several New York State and New York State Bar Association committees dealing with estate planning and elder law concerns. He is also a member of the National Academy of Elder Law Attorneys. Please welcome Lou Pierro.
Thank you, Jim. And I couldn't agree with you more as to the emotional toll that a disorganized estate can cause in a family. And who got that coin collection? Your brother David? Is that the one?
It was sold.
But all the things that you listed are real life concerns. And what we're going to try to do over the next 55 minutes or so is to lay out for the audience how to deal with some of those concerns. We talked in the first session about having a good will, power of attorney, healthcare proxy, and a disposition of remains appointment of the documents we call the Core 4. Tonight, we're going to move on from that. And if you want to see that prior video, it is available. And we can point you to the right place to get that later on in the program. But now we're going to take it to the next level. And our firm here, Pierro, Connor & Strauss, is located here in Albany. We're also in New York City. And we have offices on Long Island and Lake Placid, Utica. We are also practicing in Massachusetts, New Jersey, and Florida. So these are our attorneys, and we are all specialized in some area of estate planning, elder law, special needs, and business law. And that's what our firm focuses on. So we call ourselves a boutique law firm. So tonight, we're going to cover President Biden's agenda. He just made his first address. and first press conference, I should say. And we're going to talk about his tax proposals and how they may impact you and what we all have to look forward to there. And then the inevitables, death and taxes. Well, one is inevitable. One, they say sometimes is voluntary. So we're going to talk about ways that you can eliminate estate tax, some cases income tax, how to protect your assets, gift and estate tax planning, and a topic that I think is extremely important, and that is doing well by doing good. And by that, I mean utilizing charitable planning and philanthropy as part of your estate plan. And I'm going to show you a few techniques where we can create a real win-win situation for you and your favorite charity. Before we start, we're going to take a brief poll. And there are our poll questions. We just want to get an idea on who we have in the audience tonight. So if you're from Columbia Memorial, you're an employee, supporter, donor, or business professional, a community member. We should have put other on there because there's probably some of you that don't fit any of these categories, but let's show our results. And there we have it. So that's our audience. So I'm going to talk at a fairly high level, but make sure that everybody knows what we're talking about as we go through these slides. So let's start and talk about this guy, Joe Biden. Not your average Joe anymore, but he came in facing the COVID crisis. And I think we have made significant progress in terms of vaccinations. We'll see how we do in terms of the results of the vaccinations, but we're hopeful, as he said, that by 4th of July, we can all sit around unmasked and have close conversations and get back to some semblance of normalcy. The economy needs to recover. We have a $1.9 trillion COVID relief bill that hopefully is going to stimulate the economy and get job growth back. Racial equality is an issue, climate change, all major issues. And now, last week, he unveiled his infrastructure plan, which is a $3 trillion plan. And as you might imagine, if you're spending $1.9 trillion on COVID relief and $3 trillion on infrastructure, the government needs to make money somehow. How does the government make money to pay for all of the bills? It taxes you. And so we're going to talk about a number of different taxes tonight, but I just want to point out, and this is kind of a bright spot for me, I do a lot of elder law, that President Biden has, in his campaign, as part of his platform, and also as president, he has done a little bit more than pay lip service, but he has really put in play ideas and change at the Center for Medicare and Medicaid Services to try to improve the system of home health care. That's where most people want to age. Aging in place is something that we try to reinforce for our clients and build plans that allow them to be in their most comfortable setting. And for the first time, really, since Lyndon Johnson's Great Society program, we have a president who's taking this issue seriously. But again, for healthcare, we have to pay. And this is his proposal to add a 12.4% Social Security payroll tax to cover those expenditures, half of that from employees, half of that from employers. We'll see where that goes. And he's also talking about bringing the ordinary income tax rate, and we'll talk more about this later, from 37%, where it is today, back up to 39.6%. With regard to that income tax rate going back to 39.6, but only if your income is over $1 million. So clearly, they're looking to increase the tax on higher earners. But the next one is something that would hit everyone. And to kind of put it in perspective, if your mom and dad bought a house and they had the house for 50 years and the house cost them $50,000 and now it's worth $250,000, there is a $200,000 capital gain that you would have to pay, they would have to pay tax on, but it's their primary residence, so they get an exclusion. If they were to gift that house to you, you get their same basis. But right now, if they die with that house in their estate, the inheritors, typically the children, get a new basis of $250,000. It's called a step up in basis to the market value on date of death. The kids then sell the house, they pay zero capital gain. Now, under the new rules or the proposed rules, that $50,000 original basis, even at death, would carry over to the kids. And now when the kids sell the house, they have a $200,000 capital gain, and they would have to pay capital gains tax on that. And as we're going to see, depending upon who the kids are, that may be at a higher rate. So we have our second quick poll. What are the top 3 poison arrows that can pierce an estate plan's effectiveness? So a lot of people don't have any estate plan. Many people today, they say over 60% don't even have a will, let alone a power of attorney, a healthcare proxy, and a disposition of remains appointment. But what things can derail your plan and put your heirs through a significant burden and cost? Pretty spread out results so far. All right, let's show our results. Family disagreements, boy, we see a lot of those. A well-structured plan certainly prevents that, and we're going to talk about the place where those disagreements play out. Taxes, yes, but we're going to talk about the estate tax and where that's at today. Biden's proposal to change that. Divorce, certainly an issue. We want to protect assets for our heirs. Probate is a major problem today, especially during the COVID and post-COVID era. Courts are backlogged, and every will has to go through that court probate process. Which party controls Congress, unfortunately, plays into this far more than it should. This is a politically charged area, and creditors. So that's our result. Let's go on and take a look at those poison arrows. So one of them deals with court, the other may deal with court. Probate, what is it? Why is it something that you should avoid? We're going to talk a lot about that. Trust planning is something you can utilize to avoid probate. We're going to show you how all of that works. This one is something that more and more people are thinking about. When I leave assets to my children, I have 3 kids, they're grown, and I want to leave them my estate. Ultimately, my wife and I want to leave our estate to our kids, but we want to leave it to them in a way that is protected. If they get sued, if they get divorced, if they need long-term care, is there a way you can protect that next generation? We'll show you how that works. And finally, taxes. And the tax man cometh in all different types of tax, and we'll talk about that as well. So let's see, there we are. What's the problem with probate? Probate is a court process, and many of clients come to us and say, well, I have a will, so I avoid probate. You have a will, so you need probate. Every will, in order to be validated, in order to have any effect, has to go through court. So you prepare a petition, a number of other documents, you submit it to the surrogates court in New York State. That's where the probate process takes place. The judge then reviews all of your paperwork. People have opportunities to come in and object. This is where those family squabbles typically play out in an estate, and it could be over millions of dollars, or it could be over a piece of jewelry that is sentimental. As Jim said, very often it isn't even the money, it's the emotion that goes with it. So you have court costs, administrative costs, legal fees. I don't object to that, but you can avoid them. Will contests, delays, and right now, again, the COVID crisis has pushed the courts back. They were closed for several months. Now they've reopened, they had limited staff, and they're really just going through 2020 backlogs at this point, cleaning up the proceedings that are pending in their courts. So if we can avoid probate, that's a good thing. Second poison arrow, liability protection. Lawsuits, creditors, divorces. If you're on a board, corporate board, you have directors and officers liability. If you're a professional, you may have malpractice liability, employee suits. But the last one is also very important, and that is nursing home costs. How do you protect yourself from creditors that are healthcare creditors if you need long-term care? We'll touch on that. And finally, taxes. And the Beatles had a song, The Tax Man. And it said, if you want to walk, we'll tax your feet. Well, the government kind of comes at you that way. And income tax, payroll tax, vicarious liability for other people's situations and taxes, gift tax, estate tax, capital gains tax, something most people have never heard of. If you skip a generation and go from grandparent to grandchild, there's a generation skipping transfer tax, and there are more, real property taxes, etc. So how do we beat this? First step, let's talk about the probate situation. How can we keep our heirs, our children, our spouses out of court? And that's my job. As a planner, I want to keep you out of court for your lifetime and beyond. The Revocable Living Trust is the tool that is our chief tool to avoid probate. You can create this trust. You can be your own trustee. You're the beneficiary, but you have a document and a trust, which is a contract between you and the trustee and the beneficiary, that then upon your incapacity would have a successor trustee. So your initial trustee, if you can't be trustee anymore for whatever reason, your physician determines you're unable, you have successors that you choose, you appoint, and these people are your choices to be your surrogate and manage the trust on your behalf. The key here is upon death, that trust just turns over to that successor trustee who, without a court, without a judge, steps in and begins to administer the trust and has immediate access to all of your assets, all of your property. So no time delay, no cost of probate, no court cost. There are some modest administration fees for a trust, but nothing close to having to go through all of that probate process. In a revocable trust, you don't have to serve notice on any of the beneficiaries, so you don't have an open forum for people to come in and object, and it can create inheritances for your kids that are going to be most beneficial for them with the least amount of shrinkage from lawyers' fees and accounting fees and court fees. And now let's look at the inheritance for the children. So revocable trusts are your protection to avoid probate. You can, through that revocable trust, then instead of having your trust end when you die, many of our clients today, most of our clients who are parents, have that trust continue and simply divide so that each of your children receives their inheritance in trust. The special features of this trust is it's fully protected from divorces, from lawsuits. It's not taxable as part of their estate. If they need Medicaid, it's Medicaid protected. Yet they can be their own trustee and they can have full access to all the income and all the principal. So you can, in effect, create for your children a much, much better situation than you could create for yourself. And this is a schematic of how that trust works. Your revocable trust, there for your lifetime. It divides out. Your children each get a trust. And if they're all capable, they're all their own trustee. We may have children that are disabled. We may have a special needs trust with someone else as trustee for a disabled child. You may have children that are spendthrifts. They have gambling issues, drug issues, alcohol issues. You would create a trust for them and again, name someone else as their trustee. But if your children are able, this is a trust there that they can be their own trustee, have full access and control, and still get the protections of a trust that's fully creditor protected. So it's a pretty good deal. And you can do that easily right through your revocable trust. So you're doing a second generation of planning. And if you have grandchildren, this trust guarantees, we call it a bloodline trust, that the assets that you've worked your lifetime for benefit your kids, but then make their way on down to your grandchildren, as opposed to going out to spouses or others. And you can do all that through this beneficiary control trust. So why is asset protection important? You've built wealth during your lifetime. You want to make sure that it doesn't get hit by those probate fees, by creditors, by attacks from disgruntled beneficiaries. You want to make sure this is all going to get where it's supposed to go and be protected. Can you do this for yourself? Well, there are a lot of different ways that we do asset protection. Insurance is the first line of defense for most people. And you have a homeowner's policy. You have an automobile policy. You may have a boat and have a boat policy. You have other types of insurance, and those would have liability coverages. One very inexpensive way to get additional coverage is an umbrella policy, which can sit over all of those basic coverages and give you $1 or $2 million of additional insurance in the event that you get in that car accident or you have somebody fall at your home. You've got additional protection. State law will exempt certain assets. Retirement accounts are protected assets. So your IRA and 401k, for creditor purposes, for you, the participant, is exempt. Once that goes to heirs, it loses the exemption. But for you, it's an exempt asset. Your home, you may think, is exempt, but in New York, only about $125,000 in equity of your home is protected from creditors. So we set up limited liability companies, partnerships, corporations. We do exotic trusts in places like Nevis and the Cook Islands, which are offshore asset protection trusts or foreign asset protection trusts. We do trusts in Delaware, a lot of trusts in Delaware, some in Nevada, again, for asset protection purposes. But we want to make sure if we're going to go to that length, that it's worth the price. You can do that for yourself, but you cannot create any of those asset protection trusts for yourself in New York. You have to go to another state. That means having a corporate trustee, and it adds significant cost to your plan. But if you leave that beneficiary control trust for your children, they get all the same benefits of that Nevis trust that you could do, but with a trust right here that they're their own trustee of. Again, it's the best deal that we have to offer. And finally, that long-term care risk, that nursing home, home health care risk that we talked about, long-term care insurance is the primary defense for that. But if you don't have it, and many people don't, then you're either going to pay out of your pocket or you're going to pay through Medicaid. And we do a lot of Medicaid planning in our office. It's the only benefit. Medicare does not cover any long-term care. So if you don't have private insurance, the cost of care now is up to about $180,000 a year for nursing home care on average. Home health care could be more or less depending upon how you're getting it and how much you need. But who's going to take care of you? Where do you want to be? How are you going to pay for it? If you don't have sufficient income to pay $180,000 a year, and most people don't, then you're going to be relying on assets. And we want to protect your assets and allow you to qualify for Medicaid. So the one kind of trust that you can create and protect yourself from a creditor, that's the Medicaid creditor, is the asset protection trust, which is an irrevocable trust. You would put assets in, you would keep the income, but ultimately that trust passes to your heirs. You would put a home, bank accounts, stocks and bonds, annuities, life insurance, business interest, real estate. All of that goes into the trust. You retain the right to live in your home. That's a legally protected right, kind of like a life estate. The income is yours if you want it. The principal stays in the trust, but the principal could be transferred to third parties, i.e. your children. Once your children get it, they're free to do with it what they will. So if you have a tight family relationship, this trust isn't so bad because your kids can get the money and then use it back for your benefit. That's case by case, and you have to know the family relationship. But this trust is something we do every day for people who want to save their assets in the event they need nursing home or long-term care. The big exemption in New York is your IRA, 401k, 403b. Any retirement plan is exempt for Medicaid purposes in New York State. So you keep that. You have to draw your distributions, RMDs. The income is countable, but the asset is exempt. So we leave that out of the trust. We also leave a certain amount of cash and bank accounts outside the trust. And to make you feel more comfortable with this trust, if you're considering it, you name initial trustees, but you can change trustees at any time. You name the initial beneficiaries, but you can change beneficiaries at any time. And with the consent of those beneficiaries, this irrevocable trust actually goes back and becomes a revocable trust. You just can't do it on your own. You have to get the signatures of beneficiaries. But if you can change the beneficiaries, odds are you can find friendly beneficiaries who are going to capitulate. So if you set the trust up and you want to get the assets back, it is possible under New York law to do that with the consent of the beneficiaries. So that's asset protection planning. Insure the risks that you can insure. If you need to take the next steps and you want to do it for yourself, you have to go either to Delaware, Nevada, or offshore to create asset protection trusts for yourself. Do it for your children. You can do it very simply and leave them in control and still get the asset protection. Best deal in town again. And you want to make sure if you are planning for long-term care and you don't have long-term care insurance to cover that risk, that you consider an asset protection trust for Medicaid purposes. Now let's turn to tax. And the tax laws have changed already. If you go back to January 1 of 2020, we got something called the Secure Act. And this impacted everyone that has an IRA, which I would say today in our office, that's 90% of our clients have some type of IRA 401k qualified plan. What they did was they changed the rules. Some of the changes were okay. You can now pull money out at 72 instead of 70 and a half. But the real poison pill here, the poison arrow, is that when your beneficiaries inherit it, they have to take it out instead of over their lifetime. They now have to take it out over 10 years. So that's causing us to really rethink how we plan for retirement accounts and IRAs. And many more people are doing things like Roth conversions, and we're doing more sophisticated planning. There are certain exemptions to those rules. If it goes to a surviving spouse, they still get to use the old rules, the life expectancy, or even do a spousal rollover. If you have a disabled child or leave it to a chronically ill individual, they can also stretch it over their life expectancies. If you have a beneficiary that is less than 10 years younger than you, they can also take it out over their life expectancy. But these rules got very much more complicated. And when you think about it, an IRA is 100% income taxable. And if your beneficiary has to take it out over 10 years, they're going to squeeze out. What the government wanted to do was take it and squeeze all the income out over that 10-year recipient's period and collect the income tax on it. So they're going to get paid a lot sooner than they were under the old rules, where they could be stretching that IRA over their lifetimes. So Roth conversions are extremely popular right now. We're also looking at ways to structure the beneficiary designations to take advantage of certain rules. We're going to talk a little bit about charitable trusts as we go forward, and that's a beneficiary that you can name an IRA the beneficiary of, make that charitable trust, receive it, doesn't pay any income tax, can reinvest it, and then pay income off of the full balance to the beneficiary. So again, some sophisticated planning. Very often we tie life insurance into this planning if we can, if you're insurable and it's affordable. But IRAs now need a second look. If you haven't really looked at it since the Secure Act came into play, you need to sit down with someone like Jim, your financial advisor, or an attorney or an accountant, and really look hard at how that IRA is playing into your estate plan. So we have IRAs, and that's one class of assets. We have to look case by case at what you own. And people think they can take a document, a will or a trust off a shelf and just sign it, and it's going to cover their needs. But estate planning is much, much more than just a document. You have to look at the securities, the stocks, the retirement accounts, real estate, life insurance, business interests, your tangible personal property. Every item that you have needs to be accounted for in your plan. And we have to tie it all and thread it all together. And when we do a revocable living trust, we call it trust funding. You take all of these assets, except retirement accounts, and you transfer them into the name of your revocable trust. So now instead of Lou Pierro, it's Lou Pierro, trustee of the Lou Pierro Trust. I'm still the same guy, I still control it, still 100% mine, but now I simply own it and manage it as trustee. If I have that event where I'm not able to manage, my wife could step in as my successor trustee and manage the same account on my behalf, children, next, whoever your successors are. So knowing your assets and getting a good inventory is critical. We use a questionnaire for that purpose. We have a questionnaire if you're doing basic estate planning or if you're doing more long-term care planning and looking at Medicaid planning. And either of those questionnaires is available on our website, which is pierrolaw.com. So the tax bite, tax man cometh, as I said before. These are the current rates on the left. Federal, 37% income tax rate, top bracket. New York, 8.82%. If you live in New York City or you're earning New York City income, you pay a VIG of 3.6%. If you have net investment income and you're over a certain threshold, $400,000 of total income, you pay an additional 3.8%. So those lucky enough to be in the high tax brackets in New York City pay over 53% income tax, and you can back out the others, but you're still going to be in a significant bracket. Capital gains tax rate, the maximum now is 20%. Many people pay 15%. New York State charges the full boat, 8%, 8.82. New York City, you pay the full 3.6% on capital gains, same net investment income tax. So you could even have a capital gains tax rate of 36.2%. These are confiscatory taxes. Now, these numbers all change, most of them, on December 31st of 2025, because we had a series of tax cuts back in 2018, called them the Trump tax cuts. And those tax cuts for individuals were temporary and they expired. So on January 1 of 2026, all of these rates go up and the income tax automatically goes back to 39.6% without any legislative change. So we have to be aware that tax change is coming regardless of whether it happens under the Biden administration or it happens under the sunset of the Trump tax laws. For estate and gift tax, a lot of people don't realize that right now you have an ability to gift or have in your estate $11.7 million federally. For a married couple, that's $23.4 million that can be gifted today or passed through an estate today, tax-free. Now, that sunsets as well, and it goes back to $5 million adjusted for inflation. So it'll probably end up in 2025 somewhere around $6 million, but that's going from 12 to 6, it's being cut in half. And you have an opportunity now, if you have large estates, to make that gift and lock in your $11.7 million exemption. We have done a lot of these plans for clients in the fourth quarter and in the first quarter of this year, and people are locking in that exemption. There are some sophisticated tools we use to do that. But in New York, we also have an estate tax, and it's on estates of over 5.9 million. But New York has no gift tax. So there's a significant opportunity if you want to use your full exemption, 11.7, you make that gift now. If you survive 3 years, because there's a 3-year clawback in New York, you escape tax in New York and you escape tax federally. So a lot of opportunity to plan with the new rules right now, today. And a lot of people are taking advantage, especially with that $3 trillion infrastructure bill. And this has gotten so political now. The filibuster, if you're watching the news, is on the table because they know they can't pass any of these things without getting rid of the filibuster. If they get rid of the filibuster, then they can pass all these bills on a simple majority vote. And as you know, it's 50-50 with Kamala Harris having the deciding vote. So the political game is going to impact how all of these bills take place and how this legislation moves forward. But there are lots of good reasons, as I said, to lock in your exemption. If you have a large estate, now is the time to act. These are some of the estate planning tools, and obviously we don't have the hours necessary to go through all of these, but there are significant opportunities for estate and gift tax planning. Many people, famous judge said, as I read it, the estate tax is a voluntary tax. You can either take steps to plan or you can pay. And people who do plan and plan well can really avoid the estate and gift tax entirely. So I'm going to turn now to the topic that I had mentioned earlier. So we've talked about probate avoidance, revocable trust, asset protection for yourself, ways that you can shield assets through that string, insurance, limited liability companies, trusts, if you want to really get asset protection for yourself. The fact that you can protect your beneficiaries simply and elegantly with a beneficiary control trust, and looking at then the asset protection, the probate avoidance. Now let's turn to charitable tax planning, because we know that we have a certain amount of money that's ours and a certain amount of money that's the government's. On your IRA, that's income tax. If you have an estate tax, that's going in that direction, capital gains tax, etc. So how can we change the paradigm where we have a piece that we can keep and a piece that we're going to have to pay tax on? Well, one way, and one traditional way, has been by life insurance. So if I have a tax liability on my IRA from income tax or on my estate from estate tax, then I can buy life insurance in that amount, prepay the tax, and have a policy that will pay out tax-free, and I've insured the risk. Now the full estate can pass on. It's a pretty good plan, and for many people that plan works, and we do that quite frequently. But if you want to get deeper and you look at the capital that you have available, your assets and your income, that's your financial capital. How does that divide up? Well, you have personal financial capital, which is what you're going to consume during your lifetime. and what you're going to leave on to your heirs. So lifestyle and inheritance, and then you have social capital. And social capital can be something as confiscatory as an estate tax, which is over 50%, or an income tax, which is going to go back to 39.6 and then 8.82 for New York, or it can be something much different. We can have government directed, which is the tax, or we can have self-directed social capital. What is that? We can leave money to charity, and when we leave money to charity, we generate deductions. And when we generate deductions, we reduce our tax liability, income tax, capital gains tax, estate tax. We can hit them all with proper charitable planning. So why do people give? Let's launch our next poll. We have a lot of clients that come through our doors. We talk to them about their legacy, how they want to give to their kids, their families, and how they may want to give back to their communities. And here are some of the reasons. So why do you think, or why would you consider giving to your favorite charity? Give you a few more seconds. All right, let's show our results. And here's the right reason to give: compassion for those in need. And most of you identified that one. Tax benefits certainly play into this, and we're going to talk about how you can do a win-win where you and the charity can both benefit. Lack of heirs, some people just have charities that they want to benefit. And delaying capital gains tax, deferring tax, eliminating tax, supporting your community-based hospital. I'm glad 43% of you said that one. And then increase wealth for your heirs at death. And we're going to show how that actually all can work together. So let's get out of the poll. And we want to screen share.
Can you click out of it?
I am not sure. Any thoughts on how to get through? There we
There
go.
we go.
All right, little technical glitch there. So looking back at our dollar, hello, George. How can we keep more of that dollar? How can we make the best use of that dollar? Charitable planning plays in, and we can replace that tax burden with charitable planning. And if you think about where your tax dollar goes, this is just a little budgetary item of how tax money gets spent. Now, some of this is necessary, but you don't have any control over it, and you don't know how the government's going to be spending it. And if you watch the sausage being made in the factory in Washington, you know that this isn't always the best process. So there are ways to give to charities that are basic ways. You can simply give cash, write a check. That's how many people do it. You can look at giving securities, real estate, other property during your lifetime. We can do a legacy plan where in our will or our trust, we include charities. We can name a charity as a beneficiary of an IRA. We're going to talk about that next. Life insurance is often used because you can leverage your gift, buying a life insurance policy. And next, we can get a little more sophisticated. We do a lot of charitable trusts for both income, capital gains, and estate tax avoidance purposes that provide significant benefits to the family and significant benefits to the charity. So we're going to talk about those, but let's take a look at one of the best ways right now today that you can give. If you're over 70 and a half, you can gift directly from your IRA. And remember that IRA is 100% income taxable. You can withdraw up to $100,000 per year and contribute that $100,000 to a charity, and it doesn't show up anywhere on your taxable income. So your adjusted gross income is reduced, and you don't have any extra taxes to pay, and you can leave it. Oh, we're not.
Yep, we've been stuck there for a minute, so thank you for your patience, Lou. We're just going to
All right.
move to where you were. Tim, what slide is that?
You can go to the government slide, just so people
one?
see how messy that is.
This
Next
one?
one up.
Apologies.
Okay, and run it,
There we
run
go.
show. Okay, so you want to do the run show, Beth?
For sure.
There we go. So here's where we left off. You can give 100,000 per year, no tax, not showing up on your adjusted gross income. You follow the same rules as you do for a rollover of your IRA. So make sure you work with your financial advisor to get that right. You don't want to miss this and thread the needle, but you can give up to 100,000 a year. I have a client that pledged. She was a widow of a physician. He was in a hospital in New York City, had a wing named after him. She pledged $1 million, 100,000 a year from her inherited IRA, tax-free, right off the top. So that's an excellent, excellent way to draw dollars now to give directly to a charity. Remember our capital gains tax. If you sell stock that has appreciated, you're going to pay capital gains tax on it. You can eliminate that capital gains tax by contributing that stock to a charity. You get the full deduction based upon the fair market value of the stock. The charity then sells the stock and pays no tax. So rather than writing a check to give, let's say $1,000, and you give $1,000 check, and you take a share of stock that you have a $10 basis, and you give $1,000 share of stock, you get the same deduction for this $1,000 share of stock, but you keep $1,000 without any capital gain left in your bank account. So highly appreciated assets can be gifted to charity, and you can have the charity then sell it. They're tax exempt, they pay no tax. Those are some of the best ways. And very often clients come into us and say, well, I've left the charity in my will $100,000, and I've left my IRA to my heirs, to my kids. And I say, okay, so you've left your children 60 cents on a dollar in the IRA because they're going to pay income tax on it. And you've left the charity cash because all the assets in the estate get a basis step up upon death, and they're equal to the fair market value. Just reverse it. Leave the IRA to the charity. They get 100 cents on a dollar. Leave the other assets through the estate to the individual beneficiaries. They get 100 cents on a dollar. The government gets nothing. So it's a way that you can take a fairly taxable or highly taxable asset like an IRA, go to charity. Other assets that are tax-free go to individual beneficiaries. So for our last 15 minutes, we're going to talk about some of the more sophisticated charitable tools that we have. And you don't have to be a gazillionaire to take advantage of these kinds of things. And we'll talk about the different situations where they do come up. But we have charitable remainder trusts. We have donor advised funds, which are run by the charity typically, or you can use a brokerage to do that. Charitable lead trusts, and a whole series of sophisticated techniques. And if you look at that last one, we have a number of clients that have done masterful jobs during their lifetime at leveraging their exemptions, put plenty of money aside to the kids using their $11.7 million or $23.4 million lifetime exemption. And then upon death, they're setting up a trust. We're going to talk about this charitable lead trust, which zeroes out the estate tax, pays income to the charity, and when that income period is done, pays the money back to their kids with a full 100% estate tax deduction. So you can, in fact, have a zero estate tax plan. And that's something I'll touch on right at the end. Charitable remainder trusts have been around for a long time, like charitable lead trusts. And in this one, we use it to do things like liquidate highly appreciated assets. So it's an irrevocable trust where the income is being paid back to you. So you put an asset in, the trust sells the asset, and you collect an income either for a period of time or for your lifetime, depending upon your age. And that trust would be tax exempt, just like the charity. So you get a current income tax deduction when you put assets in, no capital gains on the sale of your highly appreciated asset, and you collect income on the full asset base that is now inside the charitable trust, which you can be the trustee of and you can invest. So we can draw 5, 6, 7, 8, 10% interest, depending upon age and the calculation. And you can also use this same trust to be the beneficiary of your IRA. So here are some of the details, the charitable tax code 664 and the regs. So assets go to the charitable trust, income, in this case, go to Hans and Greta during their lifetimes. When both are deceased, the remaining assets, in this case, go to Columbia Memorial Hospital Foundation. And they can have either a unit trust or an annuity trust. There's a lot of different formats that this trust can take. But very often, let's say we have a $200,000 highly appreciated stock. We don't want to pay the capital gains tax now. We put it into the trust, we sell it. We're going to get a charitable income tax deduction of about $20,000, $25,000. Take that currently against our income, again, saving a little more. We sell the stock, we net $200,000 because there's no tax within the trust. We reinvest the stock inside the trust. There's no tax on accumulations within the trust. And let's say we take an 8% payout off of that stock, we're going to get $16,000 a year in an income for life off of a $200,000 stock sale. So these trusts are very powerful if you have highly appreciated assets, or if you want a very sophisticated tool to use to collect your IRA benefits, then you would name your children as the beneficiaries. Well, in this case, who loses if we put the assets in, we collect the income for our lifetimes, but at the end of the day, the charity gets the money. And this is just a schematic of how that works. We can use what we call a wealth replacement trust. So if you put $200,000 of stock in and you get $16,000 a year back, and you go out and you take a piece of that $16,000 and you buy a life insurance policy for $200,000, you get extra income during your lifetime. Your kids are going to get the same $200,000 they would have gotten from the stock, and the charity gets the $200,000 out of the charitable trust. So it doesn't work in every case, but if your numbers work, this is a tremendously powerful technique to liquidate assets, collect income for life, have replacement of assets for the kids, and then benefit a charity in a very, very significant way. The flip side of this is a charitable lead trust. So you have remainder trusts where you get the income, charity gets the remainder. You have lead trusts where the charity gets the income and your family gets the remainder. And these trusts right now, because of very, very low interest rates, we're in the ultra low interest rate environment. These trusts are immensely powerful. So it's irrevocable. The income goes to charity, current gift tax, and if we structure it right, income tax. So when we put assets into this trust, we generate an income tax deduction of 100% of the contribution, and there's no gift tax either. It's a totally tax-free transaction. We get to deduct the full amount of the contribution off of our current income tax return. Charity gets money for a period of years. Right now, the term is about 20 years to zero it out. And at the end of that 20 years, all of those assets come back to your family, the remaining balance of that trust. Again, we can use life insurance here to replace the value of assets. 20-year term policy, if you die within the term, the kids are going to get the money. And then at the end of the trust term, they'll get the remainder of that trust as well. So in this case, income to CMH, the remainder to a family trust or to the kids directly, 100% tax deductions for income, gift, and estate tax. And you can do this either during your lifetime, or as I said earlier, you can actually create this trust at death and zero out the tax on your estate. This is the schematic. Donor, you, puts money into the trust. Charity gets the income off that trust. The heirs end up with the balance of the trust after the period of time. And again, it's about a 20-year period right now. And you get a full income tax deduction and gift tax deduction for that trust. And it's a good way to fund the charity immediately, but still have that benefit going back to your family at the end of the trust term. So when do these come into play? We use them a lot for people who have significant stock options because those are income taxable if they want to exercise a tranche of their options. I have a client that I started this with, and he thought I was crazy when I proposed it. He now just did his 4th charitable lead annuity trust because he's been exercising his options and getting tax refunds from the withholding, and he kind of likes that idea. And now he's got this income stream flowing in to all of his favorite charities, and that money is going to end up going back to his family at the end of the trust term. So non-qualified stock options, exceptionally large incomes, lottery winners, we've used them for. Someone who has sold a business and needs to shelter the income tax consequences of that, or for athletes getting large signing bonuses, high income people. This is a very powerful trust. So at death, again, we can zero out your estate tax by using a trust like this, not funding it now. So you do a revocable trust, you leave as much as you can shelter to your family, and the balance goes into this charitable trust, income to charity for a term of years, remainder back to your family at the end of the day. So it's a powerful tool. Again, low interest rate environment. And this is the zero estate tax plan that we have implemented for a number of clients who just don't want to pay tax. They want to leave it directed. So that social capital concept, you get to direct your gift as opposed to giving it to the government and having them deal with it in the way that Congress does. A lot of people use these. You don't have to be famous. You don't have to be ultra wealthy to do it. But these are 3 examples. Jackie O had a testamentary trust, charitable lead trust in her will, and left a significant amount of money in there. And ultimately it went to her grandchildren at the end of the charitable trust term. Warren Buffett's estate plan was published in the Wall Street Journal a number of years ago. And he at that point had 32 charitable trusts in a pipeline of different things and foundations, and basically left each one of his children a foundation that they could run. And Buffett's statement, I like to quote, and that is, I want to give my children enough so that they can do anything, but not so much that they can do nothing. And that's his philosophy. So a lot of what they received was received through his philanthropy, and Mr. Zuckerberg has also done charitable trusts as part of his estate planning. So this is an analysis of the different types, the inter vivos, living trusts, Buffett and Zuckerberg did. Jackie O did the testamentary charitable plan. So that brings us to the conclusion of our program.